You're watching Reality Check. It's been almost exactly 2 weeks since that shocker of the news that the Delhi police had filed an FIR of sedition, no less, on the basis of a protest advocacy document, now known as the Toolkit, tweeted by the climate change activist Greta Thunberg, linking her tweet and the document to some sort of global conspiracy behind the violence on Republic Day. For 2 weeks, as the police began to ramp up its case and to make arrests of activists on the basis of this sensational, credibility-stretching claim, there was no sign of the FIR, making it hard to comprehend the basis of the police charge. Given that a bare reading of the toolkit suggested nothing seditious, simply an assortment of different protest techniques, none of them calling for or inciting violence. Now finally the FIR has surfaced, and unsurprisingly, it does not tell us clearly how the toolkit amounts to sedition, instead relying on seemingly disconnected groups and events to link the toolkit to some sort of international violent conspiracy. The charges, as we mentioned in the FIR, are sedition, promoting enmity, criminal conspiracy, serious charges. But what about the proof? The FIR begins by naming the radical Sikh group called Sikhs for Justice, but that has no link to the toolkit. It says an effort by banned terror organizations like Sikh for Justice to disrupt Republic Day. But again, as we said, SFJ is not connected in any way to the toolkit, at least as of now. Is the FIR equating harmless protest blueprints with sedition? Look at the quotes from the toolkit that it cites. In the FIR, people should stage protests outside embassies, send photos and videos in support of farmers, join the farmers' parade on 26 January, a Twitter storm on 4th and 5th of February. All seemingly innocuous protest activities. It also talks about how the toolkit targets India's chai and yoga image, and also refers to the Poetic Justice Foundation, a Canada-based organization that, according to the police, was being promoted by the material in the toolkit and a group that tends to create feelings of enmity. On the basis of all this, it goes on to make some fairly unsubstantiated allegations that the toolkit called for economic warfare against India and that it was calling for the targeting of certain regions of India to instigate enmity. And it's evident from the toolkit that the Red Fort violence was a conspiracy. Worryingly, the FIR also treats journalists and fact-checkers who've been named in the toolkit as potential allies in the conspiracy. Now, just remember, these journalists and fact-checking websites were named in the toolkit as influencers to be tagged in tweets. But the police say that these people and these organizations have been named by the conspirators, that is the accused, as potential allies in the plans to disrupt public order. Now, as if that wasn't enough, the police also has put out some off-the-record material today which they claim further bolsters their claim of conspiracy. But again, if you look at it, it really makes you wonder how exactly this bolsters that claim. It talks about how in early December, a person called Puneet, a Canada-based activist, contacted activists here in India, Nikita and Shantanu, both of whom are wanted by the police. It again repeats the information in the FIR about farmers' protests planned on 4th and 5th February. On 6th December, the police claim a WhatsApp group was set up. On 9th January, a global day of action was declared. On 11th January, there was a Zoom meeting. On 17th January, there was another Zoom meeting. On 20th January, this group apparently decided that the toolkit needed to be finalized and shared. On the 21st of January, Shantanu joined the farmers' protest at Tikri. On 26th, which was the global day of action, there was violence in Delhi. And then, and this is a somewhat odd claim by the police, they say that because they exercise restraint, because the police exercised restraint, the objectives of the protesters was not met. Go figure. Now, this comes just a day after yet another court has pointed out the dangers of the overuse of the sedition law, that sedition cannot be used to quieten the disquiet. The law of sedition, the court said, is a powerful tool in the hands of the state to maintain peace. However, it cannot be invoked to quieten the disquiet under the pretense of muzzling the miscreants. This was in the context of two individuals who had put out Facebook posts on the farm protests against whom the police had filed charges of sedition. All right, let's go across now to panel. I have with me Mihir Desai, who's the senior advocate in the Bombay High Court and also lawyer for Nikita Jacob, one of the accused. Dr. N.C. Asthana, former DGP Kerala, is with us. Arima Sundaram, senior lawyer, Supreme Court, and Lubhyati Rangarajan, a lawyer and researcher collaborating with Article 14, a digital media organization. Mihir Desai, let me start with you. You're representing Nikita Jacob, who I believe has got some part protection from the court, if I'm not mistaken. But again, I mean, if you look at the charges of sedition and all of that, as at least on the basis of the FIR that we've gone through, it's hard to understand how that charge has been framed. Have you been supplied with any evidence or information by the police which bolsters the sedition claim?
Thank you, Srini. Well, no, because I am as confused as you are, because from the FIR, sedition, I mean, I couldn't find anything which could really implicate these persons for sedition, because and as we know, I personally believe that sedition has no place in the should have no place in the law books. In fact, Gandhiji, when he was charged in the early 20s, had said that sedition is the prince amongst the oppressive laws in the Indian Penal Code. So it should be done away with, because it is being used more and more, if you see today, against activists, against dissenters of any kind, a little against cartoonists, against stand-up comedians.
Yes.
You take it and it is being used very, very loosely.
But before we come to the wider question of the sedition law, so just to understand from you, you're saying that you couldn't find anything in the FIR that amounts to sedition. But what about the accusation that your client was part of drafting or shaping this toolkit? What's the position you're taking on that?
Well, even if she was part of making a toolkit, how does a toolkit, you see, many campaigns were going on simultaneously in the country and across the world, supporting the farmers. Toolkit is one small contribution towards that support. How does a toolkit, which does not speak one word about violence, which does not speak one word about Red Fort, or which does not speak one word about taking over the streets or anything, how can that toolkit be constituted as can be construed as some kind of sedition?
Right. So that, I guess, is the main question. But at the moment, as I understand it, she's got some sort of interim bail.
But she has got a transit bail for three weeks.
What does that mean? Sorry, what does transit bail mean? Transit bail?
Yes, transit bail means the offence is registered in Delhi. So ultimately, she will have to get anticipatory bail from a Delhi court. But in the meanwhile, she has been given 3 weeks' time. She will not be arrested, and she has the chance of going to Delhi and applying for a regular anticipatory bail in Delhi.
Okay. Arima Sundaram, without getting into the specific merits of this case, are you also worried about, and we'll put out some data on this widespread use or rather misuse of sedition, to the point where the law almost seems to have lost all meaning? It's been applied to everything from Facebook posts to editing a document.
Look, there's a difference between a law and the application of the law. Sedition itself was brought in with the effort to see that people didn't try to use unlawful means to overcome a government, not a particular party in power,
right,
but the government of India, the governing of India.
Right.
You can call it in many words, including treason in certain countries. So sedition really originated like that. If you're asking me a question, is the law sedition overused? Yes, it is. It is greatly overused. There is no doubt about that.
Right.
And it hasn't been greatly overused only recently. It's been greatly overused for a long time. On the merits of this case, I have a slightly different opinion than what the predecessor speaker spoke. But you asked me not to comment on the merits of this particular case.
I'm not. I'm not preventing you from commenting. I just thought perhaps you may not want to, but please go ahead.
Yeah.
Please go ahead.
I wouldn't want to really, because it is sub judice, but I do want to point out that while the FIR might have a pinch or more than a pinch, we have to be treated with a fistful of salt. We have to understand the basics here. We cannot run away from the fact that 26 January happened. You cannot run away from the fact that there was violence.
Yes.
You cannot run away from the fact that from all there can be a very strong inference of planned violence. You cannot run away from the fact that this planned violence had a backing. Now, when you're looking at it and then you include section 120B, which is conspiracy,
Yeah.
then people who have been connected with such people, they could always be investigated.
Right.
And at the FIR stage, it's a stage of investigation. It's not a stage of proof, it's a stage of investigation.
Right.
So that's a different matter altogether.
Right.
But on the law of sedition itself, I feel it's the application of sedition law, which is the error today.
Right.
The law itself says you cannot wage war on India. The law itself says you cannot do any act or deed by which you're, through unlawful means, bringing disfavor to the government.
Yeah.
Now, those unlawful means can be punished in themselves.
Yes.
But sedition is overall to ensure that you do not try to overthrow a government by unlawful means.
I think that's...
And I think that is not undemocratic, that's very democratic.
Okay.
But unfortunately, the way it's been used is something
is
wrong.
another matter. Absolutely.
Yeah.
NC Astana, the point here is, of course, not at all to undermine the violence that took place or that those who are responsible for it should be brought to book. The problem, NC Astana, is that when you have a police force increasingly making very, very serious, almost alarmist charges, saying we've got the proof of this international conspiracy, all these people plotting, and then you look at the FIR and you see what's in it. And people have been arrested, by the way, arrested and also being moved towards arrest. And there's really not very much.
You see, you can't murder justice in the name of upholding the law. I mean, all of us who are appearing on this show can claim to have a substantial knowledge of law, but I would like to remind your viewers that none other than a former judge of the Supreme Court, Justice Deepak Gupta, himself has summed up the whole thing, that the charges in the case show a non-application of mind. He is very clear that moving to the capital of the country to press forth your demands is not an act of sedition. Then they have also applied section 153, 153A and section 121. Now, as far as 153 is concerned, that is wantonly provoking riots.
Right.
We have a very clear-cut judgment in the case of Priya Parmeshwaran Pillai. That's a 2015 judgment in which the court very categorically said that espousing the cause of a particular section of people could not be considered anti-national or creating disaffection amongst people at large. And the court was very clear. For 153A, we also have a very clear judgment in the case of Manzar Saeed Khan. Then conspiracy, I mean, you see, we are unnecessarily getting into the conspiracy part because we can prosecute only the Indians. We cannot prosecute, say, for example, Mohd Haliwal. He is not an Indian citizen. He is beyond the pale of Indian law.
Right.
I wrote a whole article on this in the Wire.
Yeah.
And as far as it's not just the law of sedition which is being abused. You see, if you analyze the crime in India published by the NCRB, even for UAPA in the past 3 years, 16 to 19, we have taken as many as 5,922 cases.
Right. This is the Unlawful Activities Prevention Act.
132 cases.
UAPA.
I mean, we have 6,000 cases under UAPA. Do we really think that we have got so many terrorists in the country?
Yeah.
I mean,
Okay.
by
So,
any chance, if people secure conviction,
okay,
we
it's
can
not
pardon
just
them.
sedition.
But otherwise, it's pure harassment.
okay. But at the same time, sedition is unfortunately becoming extremely central to the conversation because, as we just pointed out, of its use. And Arima Sundaram is right to say that it's not only recently that it's being used or misused, there's a long trajectory. But is there a jump? And that's why we have with us Lubhyati Rangarajan, who has been doing some research on sedition cases for Article 14. But before I come to your data, Lubhyati, the government was asked a question in Parliament about sedition cases, and they put out some data based on the National Crime Records Bureau. And let's put that first up on the screen. The government data is telling you that from 2016 to 19, that's the period for which we have data on the number of people charge sheeted for sedition. That's a total of 300 people who've been charge sheeted, with a big spike in 2017, 160 people just in that year. But if you look at the database that you put together, that actually gives you a much bigger number. It's saying 10,000 have been charged with sedition in the past 10 years. 65% of those have been implicated after May 2014 when the Modi government came to power. There's been a nearly 30% jump in average annual cases under the Modi government. Over 400 people have been booked for criticizing politicians and governments on sedition charges, Lobhyati, indicating that this is being used or misused as a tool to stifle, legitimate democratic criticism.
Right. Thanks for that introduction. Yes, this is what our data found, and we've also gone back to 2010, right? So some of the early cases in the decade, of course, revolved around the Kudankulam protests in Tamil Nadu. Again, hundreds of people, thousands of people actually charged with sedition under the UPA too.
Right.
So I think one of the things that we found, of course, through our research is that the meaning of sedition clearly changes depending on who is in power, right? So the application of the law obviously varies. But I think what has increased, as you pointed out in the last 3 years, and the NCRB also points that out actually, is that the number of cases have risen in terms of the number of cases of sedition that have been filed in the last 3 years. So clearly what's being done is that the net is sort of being cast really wide to kind of, catch as many cases as you can.
Right.
And then these questions of nuanced, evidence-based approaches to charges of sedition are sort of not dealt with at this stage. And as you pointed out in your introduction of these sorts of FIRs with these sort of vague allegations that have no link to incitement to violence is also a part of the research we found. So let me just point out 2 cases that we found non-protest related that took place under COVID times. So one person posted on Facebook saying there is a lack of ventilators in this particular state. Right? That person had an FIR filed against them. In another case, someone posted on Facebook about how there are inadequate food supplies.
Right.
And somebody else replied to that post saying, what is the name of the MLA of our constituency? And they had a case of sedition filed against them. So, I don't think the question really is, should we apply Kedarnath Singh only at the trial stage?
Right.
I mean, it's the law of the land that has to be applied across the board. I mean, I don't think there should be selective application of that judgment because it's a very clear sort of judgment. Yeah.
Right. The Kedarnath judgment, just for those who don't know, is a kind of seminal judgment on sedition defined by the Supreme Court, which is cited most often. But Mihir Desai, at the moment, your client, as you said, has temporary bail. But again, given that the charge is sedition, are you hoping that there will be relief from the courts? I mean, we have just, as we read out, this Delhi Sessions Court said you can't use sedition to quiet the disquiet. But, could all courts take that view, or are you concerned?
Well, it's difficult to predict what a given court will do in a given case. And as far as individual liberty is concerned, the recent history of our courts has not been very, very good. So, but at the same time, I'm hopeful that not only my client, but also the others who are similarly charged will be able to get protection from any kind of encroachment of their personal liberty.
But the point that Arima Sundaram makes that, sedition aside, the fact that there was obviously some design behind the violence, there could be groups behind it, the fact that your client and others were, part of some kind of global effort to hold protests?
Yes, but you see, global efforts, global campaigns as far as protests are concerned is something not new. It happens all the time. In all major protests, there is some. I mean, if I write something on Facebook, it becomes an international event. If I write something on Twitter, it goes international.
Right.
So the point is not that. Point is whether this had any link to the violence which happened.
Right.
And whether there was an intention.
Yeah.
And the intention can be seen from the toolkit itself. Is there an intention to create violence? Well, the intention is very important both in sedition and 153A.
Right.
That unless there is an intent,
Yeah.
you can't really charge a person.
Right. I think, Arima Sundaram, isn't that the point, that while you are right to say that the FIR is only the first step of the investigation, the fact is that people are already being arrested on the basis of the FIR, and when you actually scrutinize it, the material it's putting together seems completely anticlimactic. It has no bearing on the charges being made. And in fact, there are many judicial pronouncements, you know them better than I, that you can't just arrest for the sake of it. That courts have repeatedly said that the police should apply their minds. They shouldn't just arrest on the basis of your imagination.
You're absolutely correct. If anyone is arrested on the basis of imagination, the courts will immediately release them. They will wrap the knuckles of the people who are misbehaving. But that's not the point here. The point here is to say the intent. The intent does not come out in an FIR. The intent comes out through investigation. We're putting the cart before the horse here. At an FIR stage, it's a stage of investigation. Yes, there must be enough grounds to justify the investigation to this extent.
No, the arrest, not just the investigation,
it's a bona fide investigation afoot.
Yeah.
Yes, I'm coming again to that.
Right.
That the arrest itself is called for because then it's needed for the purpose of custodial interrogation. It's needed for the purpose of the investigation. It's needed to find out links with the person with other links. And it's also to ensure that the person doesn't try to escape justice. It's also to ensure that they don't try to tamper with evidence. It's also to ensure that they do not try to, influence other witnesses, like ringing up somebody and saying we better destroy these kind of records. Now, these are things which the arrest is there for. Now, whether the arrest is justified in a given case or not is for the court to decide. But we cannot generalize and make a sweeping statement here, especially in the light of what we all saw on 26 January.
Right.
It is, I don't think anyone can justify what happened that day.
No,
it is an abysmal
that violence
and if
equally,
there's any conspiracy behind
equally
that,
an act
if there is any conspiracy behind that,
sure, but equally an
if there's
act
any
of egregious violence,
that is the purpose of the investigation.
Sure, but an act of egregious violence,
whether it was concerted or not,
can't be used to justify.
Sorry, I don't agree with you, Srinivasan.
No, you can't equally.
I don't agree
while
with you. Can
while,
I tell you
while
why?
You, while
Can
no
I
one
tell
is
you
condoning
why?
the violence, you can't use the violence as a way of justifying, malpractice by law enforcement agencies or law enforcement agencies stepping outside the rails.
Malpractice can never be justified. Srinivasan, where are we going? I'm the first one to say malpractice cannot be justified. I've also gone to say that if there's malpractice in action, there should be a very sharp rap on the knuckles, or even more
that's
so for
what,
the
that's
people
why I'm questioning whether you,
that's why
I'm questioning whether you need to arrest a 21-year-old climate change activist because there's been violence on Republic Day on the basis of what evidence?
21 years makes a difference there. I don't think 21 years makes a difference there. If you're prone to commit a crime, you can commit it at any age.
Of
course. I don't think 21 is an answer there.
Of course, but then
the question is a bit different.
But I'm saying what is the ground for
arrest?
arrest?
Finish.
Right.
All right, you finish, then I'll answer you.
Well, I think neither of us will be able to finish because I'm told by my producer
I'll answer you.
Out of
I'll
time.
answer you in one sentence.
No, I'm saying I'm told we're out of time.
It's all the purposes of arrest.
Okay, very quickly,
Yeah. The point I'm making is whether the given arrest in a given case is right or not will be decided by the court. And the court will come down very strongly if it's a wrong arrest. But the point is, when the charges are such and a conspiracy is alleged, there is grounds for an FIR, for an investigation. Now, whether that investigation should have led to the arrest or not is something for the courts to see.
Okay, all right.
I'm not in any
we're
event justifying
out of
the
time.
arrest or otherwise because I don't know the facts behind it.
Okay, we're repeating, we're out of time here. Do I have time? If I have time, I'd like to actually play the quote that, in fact, Justice Deepak Gupta gave us, because that was that comment he made to NTV. So let him actually have the last word on this. From all of us here, meanwhile, goodbye.
I've gone through the documents on the toolkit, those which are available on in the public domain,
right.
And I see that there is nothing in the toolkit which says anything with regard to violence or anything with regard to inciting people. I don't see what is seditious about this document. There's another very important case, Balwant Singh's case, where in Sector 17 in Chandigarh, slogans were raised, Khalistan Zindabad and Raj Karega Khalsa. Even then the Supreme Court said, as long as those two slogans were raised, but there was no incitement to violence, this did not amount to sedition.